When you have a high net worth divorce, there are so many things that you need to make sure you look at. Usually, it involves the ownership of at least one business, if not multiple businesses. So, you're going to want to get a jump on seeing what assets the business holds and getting valuations done by experts if you need to. A lot of people with high net worth tend to own a lot of real estate, sometimes in different places. I had a divorce where the majority of the marital estate was owned in Colorado. And we had to find appraisers in Colorado to value the land so that we could present it here in Alabama. You need to get a really good grasp on what property is owned. And sometimes that involves paying somebody to do a title search in this state or maybe different states to make sure that you have the correct property description of each parcel of property. If somebody is a high earner and that is part of your divorce, you want to make sure you see how much they're contributing to retirement. In other words, are they deferring a lot of their income because this divorce is happening? And you want to make sure that you look at their history of earning, because if it's going down all of a sudden when you're going through a divorce, that's going to be a major red flag to you, and you're going to want to show what they used to earn previously. Financial documents can be overwhelming and daunting. And the more organized and systematic we are about the things we need to find out, the more we're going to be able to assure you that we're getting you what you deserve. The more complex your assets are, the more incentive you should have to try to figure out a solution that doesn't leave their division up to a judge. The easiest thing for a judge to do is sell something. If something is able to be sold, you should assume a court is going to sell it. And if you don't want an asset sold, then we need to look at another way to divide it. So you might compensate somebody with another asset to make up for their interest in an asset that you care about more. Sometimes assets are just too encumbered to do anything but sell them. For instance, if you own your home place and it's worth $2 million, but it has a mortgage on it that is $1 million, and you both are on the mortgage, more often than not, you're going to have to sell that asset because one party's not going to be able to buy the other party out. The goal with complex assets is to disentangle you and your spouse at the highest level possible so that you do not have to deal with each other financially going forward unless absolutely necessary. A lot of times people have really valuable assets that are not just a business or a parcel of land. Sometimes people have super expensive cars, or they have $1 million boats, especially in our area. If a car has been one person's car traditionally throughout the marriage, 9 times out of 10, they're going to get that car. An exception would be if they cannot service the debt that goes with that car, then it's probably going to have to be sold. Having said that, if one person has a car worth $100,000 and the other person has one worth 20, there's going to be an offset, and that compensation is going to occur either through the sale of those assets or through getting more of another asset that the marital estate might have. If you have a really expensive boat and it has a loan on it, you should expect to sell that boat. And more than that, you should want to sell that boat because it is probably a money pit. If somebody really wants to keep the boat and they can service the debt on it, then you may make a trade for that by taking more out of another asset. Another big area of contention can be if people have furnishings or artwork or personal property in their home that really doesn't have a lot of value monetarily, but has sentimental value, or the person is just really personally attached to it. And so that can actually be a place where division of assets breaks down more often than even the sale of a house. You want to be careful that you're prioritizing what actually matters when you're doing the give and take of assets in a divorce. If you are getting divorced and one or both of the parties earns above the child support guidelines in Alabama, then what we call the Rule 32 guidelines don't apply. And so it takes some extra information gathering and sometimes some creative solutions to figure out what child support should be. You're going to need to look at what the income of the biggest earning party is, and how far above the guidelines the combined incomes are. But you're also going to want to look at what are the reasonable needs of the children and who are they going to be living with and how are they going to provide for that person. So, for instance, if somebody has 3 children and they have typically sent them to private school and they typically take ski trips every Mardi Gras and do all of those things, those are not going to necessarily be court ordered expenses, but they are part of what was a standard of living for that family. So those things may or may not be considered by the court. What will always be considered is basic living expenses, clothing, food, transportation, and those sorts of things. It's just that it's a lot harder to predict what that child support number is going to be if you have an income that exceeds the guidelines. So we will run through multiple scenarios and figure out the closest number that you can expect from a judge. And usually, if you can reasonably justify it and the other person can pay it, a judge is going to consider the number you give them for child support. So in Alabama, the law says that alimony is necessarily intertwined with property division. So judges have options to possibly give somebody more of the marital estate and less alimony, or less of the marital estate and more alimony. One has to affect the other because a consideration for alimony is the separate estate of each spouse. And if a spouse is walking away with a higher separate estate, they may not be entitled to as much alimony. The other consideration when you're dividing assets is, does that asset produce income for the spouse receiving it? If somebody is getting rental properties that always stay rented, or they're getting investment accounts that the parties typically live off of, that is going to generate income for that spouse post-divorce that they didn't necessarily count while they're going through the divorce. So that may actually be a benefit because now they have their own source to generate their own revenue. High net worth divorces can be very tricky. They can have a lot of complications and they can involve a lot of intertwined assets. If you contact Empowered Family Law, we can help you navigate that process.